keep in mind, this is just some general advice. Every case differs, so don't take this as specific legal advice about anything. The Postal Service issues extra trips based on the extra trips clause in your contract. It's in CDS contracts. It's in HCR contracts, the clear contracts, the type of HCR contract. It's in those contracts. And under that clause, both the contracting officer and the administrative official have the authority to issue extra trips to the contractor. Now, you got to check your clause. The clauses vary slightly. For example, in the clear terms and conditions, there's a provision that if you are given notice 4 hours or more, you have to run the extra trip. There's no, in the other contracts, there's nothing that provides any specific amount of advance notice. So one would assume it would be reasonable notice. But it's very clear in the clear contracts that if you are provided 4 hours advance notice, you do have to run the trip. If you're provided less than that, nothing prevents you if you agree to do it, but you would have the right to refuse it if it's less than 4 hours. Also, under the clear contract, it notes that the trip time, the time it takes to run the trip, should be the same as in the schedule, which sounds okay, except that if you are now in a more trafficy or congested time period, maybe now it doesn't make as much sense, and that's something you should take up with the administrative official. One issue that comes up is sometimes there is not any paperwork issued. And if you look at the clause, it doesn't require that an extra trip form, the PS 5397, I think it is, it doesn't require that form be issued. It just says you have to do it. Now, in many cases, it's typically the rule, the procurement officer will say, well, if you did not get an extra trip form, you don't have to run the trip. That's great. But it's not really in the contract. So if you're confronted with a situation where you are not getting extra trip forms, what I suggest you do is contact the contracting officer and try and straighten it out. And if you want to keep running the trips without the forms, because you might want to run those trips, you get more, assuming you get paid for them eventually, it's more revenue. You might want to do it. You would say to the contracting officer, I'm getting these requests to run extra trips. I'm running them, but I'm not receiving the forms. Please let me know what I should do, something like that. If you don't want to run them without the form, you can say, dear contracting officer, I've been getting these requests with no forms. My understanding is I don't have to run them unless I receive the form. Is that a correct interpretation, or is that correct? Something like that. So you got yourself covered as to the authority issue. Now, a third thing that happens is maybe you've run a bunch of extra trips, and now the administrative official is denied. They didn't give you a form, and they're denying that you were ordered to do it in the first place, or they're just not responding. Well, now you need to get ratification, and ratification is simple. Let's suppose it's something that comes up regularly. You would contact the contracting officer and say, hey, I've been running these trips. Should I stop doing this? And if the contracting officer says, no, keep doing it, do what you were told, yes, you don't need a form, that essentially ratifies the previous trips you've been doing. So I hope we've covered that issue, at least in a little bit. I think you might next want to ask about or look at the rate. What rate should you get paid? Now, the clause basically says you get pro rata rate, which typically should be good. If pro rata rate is applied, it should be okay in most instances, assuming you don't have to get additional equipment, assuming it's not some kind of inefficiency. And so I'm not talking about peak season or something like that. Assuming you have available equipment, the pro rata rate should in most cases be okay, but it's not always. And in cases where it's not okay, the clause allows you to seek a higher rate. Now you have the obligation at that point to demonstrate the additional cost. So you have to have the receipts. You need the receipts. You got to show what the additional cost was. Say you went to lease a vehicle. Let's suppose you couldn't. The primary vehicles are all being used up, and you can't use those for these extra trips. You've got to show those costs, show the costs of labor, show it's more in the pro rata, and then you're entitled to that. Sometimes though, the contract, especially CS contracts, will specify a per trip rate, and it could be in miles. And sometimes that doesn't work. Maybe there's not a lot of miles. In the rural routes, maybe that's okay, where there's covering a lot of miles. But in more neighborhood rates where there's not a lot of miles, getting paid per mile just won't cut it. Especially, say, Sunday service. Sunday, sometimes you might be ordered to provide service on Sunday, but the extra trip rate on that probably won't work. So I would say in those cases, you're going to want to negotiate a different rate or seek a different rate. And if there is a per or extra trip rate already in the contract, I don't think, when push comes to shove, I don't think legally it'd be held to that if the circumstances of the particular extra trip didn't match the expectation of that extra trip rate. The clause, if you look at, says you got to bring a claim, if you want to bring a claim, within 90 days after the last extra trip was ordered. Typically, clauses like that are not enforced. Typically, a clause like that, for the Postal Service to enforce that and preclude your claim, the Postal Service would have to show that it was prejudiced, it was harmed by your failing to file the claim in 90 days. And typically, it can't do that because it would have asked you to run the trip anyway. So, in most cases, that 90-day rule does not apply. Of course, you should try and file it as soon as possible, because the sooner you file it, the sooner you get paid, or at least you know where you stand on it. Another thing to think about is extra trips are supposed to be ordered on an infrequent basis from the point of origin, the starting point of the contract. If you have a regular extra trip, and you might like it, and you might be okay with the pro rata rate, and that's fine, but in certain cases you're not okay with it. And if it now becomes a regular thing, what you really have is a service change. And there you're entitled to a negotiated service change. If it's more than $5,000 a year, you'd even be entitled to stop performing it at some point in the future if you couldn't reach agreement on it. But the extra trip is supposed to be infrequent from the point of origin. If it's not infrequent, if it's not from the point of origin, you'll have something different. You can always treat it as an extra trip if you want to, and you agree to that. But if it's not going to work out in your favor, you don't have to, because it technically is not that. I think the last thing I'll talk about would be what are the limits on extra trips? To what extent can you be ordered to run it? Now, in the CDS contract, there is something that says something about you have to have standby equipment that's available to you in the case of a mechanical problem, repairs, or running extra trips. So that seems to imply that you'd have to use readily available standby equipment. It doesn't say immediately available, readily available. So it's not really clear from that. The HCR contracts don't have that provision in them. So the question is, how much is too much? Now, in most cases, a contractor is not going to object to too many extra trips because you're going to get paid for it. You want the extra work. So it's usually not a problem. But I would say you couldn't be forced to do anything that was that required more equipment than the normal route requires and normal use of standby equipment. I would think that would be the limit that would be imposed. Certainly that you couldn't be asked to perform 100 times the amount of work, right? So how far down do we get to where it's a reasonable limit? And then let's say the other side of that coin. Let's suppose there is an extra trip the Postal Service needs to be run. Is it required to ask you, the contractor, to run it? Now, there's nothing in the contract that says anything about that. But the general practice has been for, 40, 50 years, as long as I know, the general practice has been that the contractor who is at that origin point is given the first right of refusal, is given the first chance to do it. And there could be an argument that that's not just being nice, that is part of the duty of good faith and fair dealing. Since the contractor is on the hook for running extra trips that are ordered, it would seem a reciprocal duty would be that the Postal Service will look to the contractor, at least in the first instance, to run such extra trips. So there could be an argument that the Postal Service does have to call upon you for that. But it's not been tested. It's not clear. We don't know where that stands. That's just an argument you might have. I would say if it does happen to you, you should certainly make your views known that you should be asked to run those extra trips. So that's kind of my little summary of extra trips. Hope you've enjoyed it. If you have any questions, please let me know. Otherwise, I wish you the great success in your contracting and happy extra trips.